The case Massachusetts versus the Environmental Protection Agency began with the passage of the Clean Air Act in 1990. This said the EPA can regulate all air pollutants potentially harmful to human health. Massachusetts sued the EPA in 2003 on the grounds that the state was losing shoreline due to the Environmental Protection Agency's lack of regulating carbon emissions. Massachusetts lost in the D.C. Circuit Court and the Appellate Court. The Supreme Court took the case in 2006 because of all the hype in the media about pop culture and global warming, climate change, and the environment in general. Also, the recent scientific studies being released and the celebrities stating they feel we need to step up and protect the environment. This case is an executive review because it reviews an action made by the bureaucracy. It is also a federalism issue because it deals with whether Massachusetts can impose regulations on carbon emissions stricter than those imposed by the EPA. The arguments in the court were quite heated. Let's check it out.
The EPA's failure to regulate carbon emissions has lost the state of Massachusetts shoreline. The Clean Air Act clearly gives the EPA authority to regulate these emissions. The EPA cannot deny this power because they are clearly stated in the Clean Air Act. You have had no immediate or imminent harm done to you. How can you be suing the EPA? These dangers are very imminent and have already occurred. The state of Massachusetts has lost several inches of shoreline already. But wouldn't it depend on what other developing countries such as India and China do with their carbon emissions? Our regulating this very small portion of CO2 would do very little. Yes, but any regulation would help in the overall cause of protecting our environment and conserving natural resources.
Woo! Those conservative justices are slamming Massachusetts because they feel that new regulations will kill our already crippled economy. They also feel that our regulating this very small portion of emissions will do very little. Let's return to our friends at the Supreme Court.
Massachusetts has told you that the Clean Air Act clearly gives us authority to regulate carbon emissions from new motorized vehicles. Nowhere in the Clean Air Act does it say this. Massachusetts has no standing to sue us since no damages have been done to it. And we also should be allowed to refuse any regulation on emissions, because these sciences are very unclear, and we should not be forced to regulate something when we do not know what we are doing. But the sciences have clearly linked CO2 emissions to climate change, and CO2 clearly fits under the definition of air pollutant used in the Clean Air Act. But the Clean Air Act never mentions carbon emissions in its wording, and the science surrounding this issue is a very ambiguous link.
Wow! The liberal justices don't like the EPA's argument because they feel we need to protect the environment. Let's see what the court decided.
The majority has decided that the EPA has the authority to regulate carbon emissions, but may deny the authority if their reasoning is scientifically based and consistent with the Clean Air Act. Disagree, do I? With the court's ruling, I feel Massachusetts has no standing to sue the EPA. I agree with Chief Justice Roberts. I wrote a dissent about how Massachusetts has no standing and how their damages were unreal. I was the swing vote in this 5-4 decision. I was convinced when Massachusetts said that their shoreline loss inhibited their sovereign capacity because I am the court's ardent defender of federalism.
Wow! That decision was pretty split. I personally feel, based on opinions I read by Ben Lieberman and Lawrence Gostin, that the U.S. needs to step up and take the initiative for other developing nations to follow, not wait for others to commit to regulating carbon emissions. Although this may cripple the economy, that is fixable, and the environment has no rewind button. Although this case may have no immediate effects under the current administration, later presidents and later EPA administrators will surely take advantage of this power, and this case will open doors for future decisions to help the environment. As far as judicial review goes, I feel it is a useful and very powerful way for the judiciary branch to check the powers of the executive and legislative branches so they follow the laws and obey the Constitution. Even though very many 5-4 decisions are made and have been made, more often than not, I feel these decisions are in our nation's best interest.